My name is Jim Malek with the law firm of Malek & Malek, and today I want to talk a little bit about dog bite law in Ohio. Just to give you a little bit of my background, my relevant background, I was a zoology major before I went to law school. Had a degree from the Ohio State University, and part of what I liked about that degree was studying animal behavior. In fact, I now have 2 dogs and 2 cats, and truly enjoy studying animals, both domestic and out in the wild. But when is somebody liable for an injury caused by a dog? And I will say, first of all, that vast majority of people are responsible dog owners. Most of us are responsible dog owners. And occasionally you can have somebody that's a responsible dog owner, and a dog can, in fact, bite somebody. It happens. But when is that dog owner responsible? So let's talk a little bit about dog bite law. Ohio has 2 ways in which the person in control of the dog could be liable or is liable for harms caused by the dog. The first is under Ohio Revised Code 955.28, and that is what we call a strict liability law. And what do I mean by that? If you are either the owner, the keeper, or the harbor, the person that owns the property where the dog resides and has control over that property, and the dog causes any harm, it could be a bite, it could be knocking you off your bicycle while you're going down the street, or jumping up on you and knocking you down. If the dog causes any harm, those categories of folks are automatically liable for the harms and losses unless you are teasing, tormenting, or trespassing at the time. Teasing, tormenting the dog, or trespassing at the time, criminally trespassing at the time of the harm. So let's just talk about those people. The owner of the dog is just what it sounds like. It's the person that owns the dog. The keeper is the person taking care of the dog. So it could be a family member. It could be the dog sitter. It could be anybody that's taking care of the dog at the time. And the harbor is the one that we oftentimes get into litigation over. And for instance, you typically have to own the property and have some degree of control over the property and the dog on the property before you can be liable. Typically the owner of a multifamily apartment complex, if the dog harms somebody in the common area, that's an area that the apartment complex has control over. They own that, and they of course can be liable for any harm caused by that dog in that area. So that's the first way. The second way is what we call common law negligence. When I say common law, that's law that's been created by judges, not created by a specific law passed through the legislative process, such as a statute, the one we just previously talked about. When we're talking about common law, it's usually a case in controversy that goes before a court or an appellate court or the Ohio Supreme Court, and they make a decision, and that basically becomes law. So you can also be liable for what's called common law negligence. And what do I mean by that? Well, common law negligence is different than strict liability. Strict liability the dog causes harm, you're liable. It doesn't matter if the dog's never caused harm before. It could be the nicest dog in the world. For instance, could be a friendly golden retriever that just happens to run out in the street, jump up on an elderly lady and knock her down. Not something that the owner would expect, but strict liability says that person is responsible. The owner's responsible. Negligence is different. I don't think in that circumstance that the owner would be considered negligence, especially if it's never done that before, jumped up and knocked somebody down or jumped up before like that. Negligence, you typically have to have some type of pre-existing knowledge of the dog's typically viciousness, and then you have a duty once you know about the viciousness of a dog to ensure that that dog stays confined and prevent it from. You have a duty to prevent it, harm by allowing it to get out and be in a position where it can cause harm to the general public, to men, women, and children that might be walking in a park or just walking in their neighborhood. And so you can be negligent if a dog, for instance, gets out of the fence because the fence isn't maintained. That's negligence. You know there's a danger there. Have a duty to ensure that that fence is properly repaired, or a door that doesn't shut and the dog gets out. Or one that I often see is people with dogs that have some vicious tendencies. And oftentimes we can find those when we subpoena the records from the veterinarian. A lot of times I'll find documentation in those records that the dog needs to be muzzled, that the dog is aggressive, that the dog is dangerous. I also oftentimes find references in those records that the dog has previously bit before. That's the kind of thing that tells you that this dog has a vicious nature to it. And so if you know about the nature of the dog, or if you know like the dog jumps all the time on people and you let it out without a leash, and it jumps up on an elderly lady, under those circumstances, the owner would certainly arguably be negligent. So negligence can actually occur even against a landlord that's doesn't have any control over the premises. Let's say you rent a single family home. It's not a multi-family apartment complex, and the landlord knows you got a dog there, and the landlord knows it stays out in the backyard, and the landlord knows that the fence is in disrepair and that the dog's been getting out. Well, then the landlord can be liable for negligence. There's some responsibility when the landlord's aware that there's a hazard on the property and then creates the conditions through non-repair of the fence or whatever to contain the dog, that can create a negligent situation even against a landlord that's out of possession, as opposed to a multi-family apartment complex. But both of those are ways that we can pursue a dog bite case for you. Again, we've been doing dog bite litigation for quite some time. We're consider ourselves experienced, and we have the resources to help you. So if you are harmed by a dog, and one last thing I will tell you, on the strict liability part of the case, you have a 6-year statute of limitations from the date of the harm, and even possibly, even longer if it's a minor child at the time. So those cases can on that part of the claim, on the negligence part, you only have the limited statute of limitations. But there are cases where sometimes people have been bit as children, and they come in here and we say, well, I think we might be able to still do something for you. So please give us a call if you have a case. We'd be happy to look at it. There's a lot of exceptions to everything, and so I can't get into all the nuances of dog bite litigation. It can be pretty involved, but I hope you've enjoyed this video, and I hope it helps you to find a lawyer. Malek and Malek, our phone number is 614-444-7440. Look forward to hearing from you. Thank you.